right, well, hello, everyone. Thank you all for joining us today. I know we still have several people jumping on and joining us in the next minute or so, but my name is Stephanie Sadisco. I am the administrator for the Admiralty Law Committee here for the Florida Bar, and I wanted to welcome you on their behalf. We do have just a couple of housekeeping items for you from the very beginning. Just to let you know, this is set up as a webinar function on Zoom, so not quite the same as a meeting. We are able to see that you are online. If you have questions though, we won't be able to see your video, and it's just to keep everything a little bit tighter. If you do have a question, there's a question and answer box down at the bottom of your screen. Go ahead and type it into there. If you're having trouble with the question and answer box, you could also click on that chat function. That will also allow us to get any questions that you have, and then that way we can address those as we go. The other housekeeping item that I would like to let you all know about, I know everyone, of course, would like to know the course number. I will be posting that in the chat function to everyone, but also just for purposes of everyone knowing where they are and making sure they are on the correct webinar right now. This is the Jones Act from a public policy and legislative perspective, CLE, and the course number is 5678. You did hear that correctly. It is 5678. And I'm going to go ahead and turn that over to Adria, and thank you again for being here.
Okay, great. Good afternoon. Thank you, Stephanie. To start off, we have a couple of notes for upcoming events in the new year. Our winter meeting is going to be held on Friday, January 28th, 2022, from 1 p.m. to 4 p.m. at the Rosen Shingle Creek Hotel in Orlando. The meeting will be in person, but we also plan to have a Zoom link set up for those who would rather attend virtually. And then in February, together with the Federal Bar Association, the Florida Bar Admiralty Law Committee will be co-sponsoring a maritime law seminar on February 18th, 2022. That's a Friday at Nova Southeastern University College of Law in Fort Lauderdale. Be sure to check your emails for more details as the dates get closer. Now I'll hand it over to you, Ryan.
Thanks, Adria. It is a great honor to introduce the speaker today. He is a distinguished Coast Guard officer. Fair Kim is the current policy director and incoming president of the American Maritime Congress. It's a trade association representing U.S. shipping companies and maritime labor union. He is a former Coast Guard officer and a judge advocate. He last served as the service's legislative counsel and liaison to U.S. Congress. He is a graduate of the University of Florida Levin College of Law. He's licensed in Florida and Connecticut, and also a graduate of the U.S. Coast Guard Academy. And he is here to speak with us about the Jones Act from a public policy and legislative perspective. And with that, I'll turn it over to Fair.
Thank you, Ryan. Thanks, Adria. Thank you, Stephanie. My name is Fair Kim. I work here in D.C. For trade association, represent U.S. shipping companies in the deep sea international trade, as well as the Marine Engineers Beneficial Association Union. And these are folks that are AFL-CIO and work on the U.S. side of things. So first of all, welcome, happy holidays. Thanks for joining me here. It's been a while since I've talked about the Jones Act to other lawyers, because mostly let me rephrase that, to other lawyers who actually practice or law students. There are a lot of lawyers here in DC. Plenty of us do not practice law. Some of us maintain our licenses, some of us don't. The people that I normally talk to about the Jones Act here in Washington, DC, they may or may not be lawyers, but mostly staffers and members here in Congress. So I wanted to address this issue from a public policy perspective as well as legislative perspective, and give some insight to folks legally, legal-minded folks there in the Florida Bar, to give you some context to why things happen legislatively with the Jones Act. The overall theme of what I'm going to talk about this morning is basically the Jones Act is a very amorphous thing, right? To lawyers and practitioners and students, the Jones Act is a specific set of rules and regulations that pertain to a certain type of law. For example, your vice chair of the Admiralty Bar in Florida, Adria, she works on specifically, liability and torts part of law, Seaman's rights of folks, specifically on cruise ships. So that's a Jones Act thing for her. Might be, the rights afforded to seamen and merchant mariners under the Jones Act. To somebody who might be representing some of the shipyard, let's say Eastern Shipbuilding in Panama City, you're concerned about the Jones Act being involved with the how a ship is built. Is a ship U.S. made enough, right? And I'll get into that a little bit more later. Somebody who's concerned with citizenship of crewing and manning, another cruise ship issue, or perhaps a bareboat charter issue, is the crew of this vessel that's carrying passengers to and from a U.S. port. Is it 75% a U.S. crew? Is it a U.S. master? Is it a U.S. citizen? What kind of U.S. citizen is it? Is it a documentation citizen, or is it a citizen, or what they call Section 2 citizen? So all of those things that I'm talking about are specific aspects of what we know as a Jones Act, but they mean different things to different people. I'm here to kind of take a bigger step back and tell you what it means from a policy perspective and a legislative perspective. And really the Jones Act, it's so amorphous. It's kind of like El Nino or something like that. It's something that people just talk about. It's like, oh, the Jones Act this, Jones Act that, Jones Act this, El Nino, polar vortex is kind of weird thing that kind of a lot of people know a little bit about, but a lot of people also know, and this is from a DC policy group, just have heard about it and know something about it from a policy perspective that was told to them by an individual or a group of folks that want them to know a certain thing about it. And that sounds kind of convoluted, but I think it'll make sense by the end of this. So just a little history of the Jones Act, and really we're talking about is the Merchant Marine Act of 1920. And really from our perspective, the Jones Act is three specific things, right? It's the cabotage part of the Jones Act, which is basically carrying goods from one point in the U.S. to another point in the U.S. And kind of include, when I say goods, you kind of can put passengers into that, and I'll talk about the distinction of that in a minute. The second part of that is U.S. built, right? What does it mean to be a U.S. built ship or a vessel? The third thing is that citizenship requirement that, Jones Act, 100% U.S. owned, 75% crewed, and the master must be a U.S. citizen. Now, this came about in 1920. Senator Jones, Washington Senate Commerce Committee chair, and really he drafted this up specifically to help his state, right? So what they were doing back then was trying to ship things to Alaska from the continental, the lower continental U.S. To Alaska, going through Vancouver, taking the same set of goods, dropping off in Vancouver, and having that foreign ship take that with a foreign crew all the way to Alaska. Wesley Jones wanted to put a stop to that because they were avoiding the port of Seattle to do that. And so that came about as to why it's called the Jones Act. But the Merchant Marine Act, of which he authored, really came about as a result of World War I. And in World War I, as allies were fractured across Europe, a lot of the merchant vessels that the U.S. had relied upon for war material or carrying troops here or there took to their own interest and kind of brought their mariners and their ships to use their own interest or kept them neutral to avoid the submarine threat. And the U.S. was at a loss because all of these international trade routes that had been supplanted by foreign vessels since the Continental Congress first enacted those first cabotage laws were now being brought to bear, and the U.S. was having a difficult time shipping things where they wanted to ship it, how they wanted to ship it, and moving passengers because the U.S. did not have a domestic fleet. So the Jones Act was in response to that, and what happened was there was a buildup after the latter half of the World War I, where all these ships were built in the U.S. to try to catch up with that. And the Jones Act also, again, since 1920, allowed those ships to basically have service use after that. So a couple of reasons with the Jones Act historically from Senator Jones, but that's where it actually comes from. They added some other aspects to the Jones Act, which was originally, the cabotage acts of the late Continental Congress. There's a Passenger Vessel Services Act of 1886. Now that's basically Jones Act for passengers, and we'll get into that. But I'm going to include it in our definition of Jones Act because that's what people talk about when they refer to the Jones Act. And finally, the 1936 was a law that actually put that citizenship of mariners in place. If you remember two things from a legal perspective, and this will be important for those of you who have practice, CBP and Coast Guard are the two arbiters of the Jones Act. I'll start with the Coast Guard. The Coast Guard talks about build. They determine what a build, if it's whether it's U.S. build or not, and the Coast Guard determines citizenship, documentation citizenship of the owners, or the actual citizenship of the mariners. CBP talks about two things. They talk about what is considered transportation and also what's considered points. So Jones Act, a lot of times people are talking about ports, U.S. ports, it's actually points. And there's a distinction there. And really, I think it goes back to folks were trying to game the Jones Act back in the day, or what was known as the Jones, precursors of Jones Act by, using non-ports, so using a train overland with the same goods or something like that, and with the same amount of types of goods to avoid that U.S. build, U.S. man requirement from going from a U.S. port to a U.S. port. So they altered that to actually say points. So that includes, anything that is in between. And I think that's an important distinction. And again, we'll get into some of the pros and cons of different arguments of that. So back to my point about the Jones Act meaning different things to various stakeholders. So, like I said, the cabotage and that goods, cargo and cabotage exist just about in all maritime nations. So that's one of those things that say, a good has to be on that nation's ships if it goes between port to port. It makes a lot more sense in a lot of places like Europe, right? Because they're taking goods and taking them to their own ports. But the cabotage part for the U.S., a lot of folks disagree with that for economic reasons. It's much more expensive at times, and the counter argument to that is that it's more reliable. And I'll get into that in a little bit later. So the shippers and shipping companies that pay for the transportation, they're on one side of the issue because they want to keep costs low to transport goods within the continental U.S. or the actual U.S. The build part, again, shipyards, repairs, that type of thing, that's a sustainment of the U.S. shipbuilding industry. One of the goals of the Jones Act was to maintain that indigenous shipbuilding and ship repair capability in times of national crisis or times of war. Right now, a current argument is we don't want to end up like the British, right? Because the British, once the greatest shipbuilding nation in the world, lost their type of domestic shipbuilding protections, if you want to use that term, and now couldn't build a ship and don't do any repairs on any ships on a very large scale. So every single warship, the Brits have is produced or worked on abroad, mostly in Nordic countries. The ownership aspect, so of course, documentation citizens is a very specific term that talks about shareholders and the autonomy of a corporation, whether that's a U.S. owner or not. I'm not going to get into the specifics of that, but it's basically the majority of owners, the stock owners of a corporation that's a U.S. company that owns a ship has to be a U.S. citizen. And then what you have is Section 2 citizens, which are kind of the private companies, which are traditionally what we think of as a traditional owner, an entity that's a U.S. citizen. And of course, licensing and mariners, different types of licensing regimes that the Coast Guard oversees. Those are the certifications and the licenses of the licensed mariners on board the vessel. And again, I just wanted to make sure that folks understood that Seaman's rights is also a part of the Jones Act. It's not something that a lot of these other entities might have a big stake in, because the ship, Seaman's rights under the Jones Act, they have a very, very specific set of circumstances where they apply. And if you're in a shipyard, before the ship is even commissioned or turned into anything, it's really quite irrelevant to you, but it's hugely important when the ship actually starts doing its business and somebody gets hurt. So Seaman's rights really talks about torts, liabilities, because there's no workers' compensation regime for seamen. And that's because of the nature of a ship. Most workers' compensation is land bound in terms of states and that type of thing. When you're a ship, when you're on a ship, you're underway. Again, if you folks are admiralty law experts, all these kind of like artificial constraints, necessarily bonds opposed to this terra firma are not really applicable, and therefore you have this issue where what applies. And if you get hurt on a vessel, there has to be some means, or the idea there has to be some means of helping you out so that you have some type of recourse if you do get hurt. So that's the basic kind of gist of the historical aspect of that, as well as kind of the stakeholders that we have. Now, I'm going to talk from a DC perspective of who thinks what about the Jones Act. And I'm just going to go kind of on a laundry list. And I will say, I probably should have said this at first. So I represent US shipping companies. So obviously, well, maybe not obviously, but US shipping companies are pro Jones Act, right? Because they help sustain the US shipping industry. They help maintain the jobs. They help maintain the national security of having US citizens and US built ships and shipyards. And so I'm going to give you the perspective, probably tinted a little bit towards a pro Jones Act viewpoint, but I also like, as any good advocate, to present the alternate side of things. I think there's fair and good arguments on both sides. One of the things about DC is that you'll have champions, right? You'll have a champion of different things. And one of the big champions for repealing the Jones Act has been Senator Mike Lee of Utah. Another one has been Representative Case. So we've got a Republican in a landlocked state and a Democrat from progressive island state that are both more or less anti-Jones Act. And I think that's confusing to some people, especially from the perspective of a landlocked states. And I wanted to give some context. No one knows, why. And before Senator Mike Lee, there was John McCain from Arizona, who was just a virulent anti-Jones Act proponent. Every single year during the NDA, which is the annual defense policy bill, which accounts for $800 billion, somewhere 80% of the U.S. discretionary budget. Every year, John McCain will put in there repeal the Jones Act, just completely take it off the books. Merchant Marine Act of 1920, which is a huge thing, right? All those different elements that we talked about, it would have completely repealed it. It's always been beaten back. Mike Lee has since then taken Senator Mike Lee from Utah since then taken the mantle, and there's different policy reasons for them to do that. One of the biggest ones is probably kind of just the free market argument, right? Protectionism, Jones Act are artificial barriers to free competition. A globalist perspective would say, let competition, Adam Smith's, invisible hand let it play out and let the most fairest, easiest, least barriers to competition prevail, lower costs to consumers worldwide, and the US will be able to compete if they can. And if they can't, they shouldn't be in that game. So there's that kind of laissez-faire attitude about the pro-business perspective, or rather the free markets perspective. Some would say that's pro-business, others would say not so much so, but that's in a nutshell where that comes from. I will say Senator Lee does have a different background. So one of the things he's been working on just from a Utah is perspective is turning certain cities in Utah into basically ports and working on a long-term plan of having a direct rail link for intermodal transport for goods to the Port of Oakland or somewhere on the West Coast that would take direct transit from goods and import and export goods as with Utah's a terminus. So that does have an impact. So those arguments that, hey, you're from a landlocked state, why are you doing this? Really, it doesn't matter, right, these days. Just as it doesn't matter with folks who are paying attention to the shipping shortfall of labor and the bottlenecks of shipping that people are talking about these days. A lot of those folks are what we call red state or flyover states, with agriculture products that are going to eventually go out on, intermodal containers out to different countries via sea. So it doesn't really matter where you've come from in terms of your policy stance or your credibility on these issues. Now, the build, of course, the U.S. build part with shipyards, that's another issue that you can see both. It's a little more obvious to see that both. Shipping right now, the last government report on shipbuilding in the U.S. something like 4.5 times more expensive to build a ship in the U.S. For different reasons, and then let's say South Korea or China or other places, and even places in Northern Europe. Obviously, a big part of that is labor costs. So there's arguments saying, why is our budget, our defense budget, so big when we could shrink it by building cheaper ships abroad? The counter argument to that is, do you really want to have your ships and your national security, your next warship, go to the lowest bidder on the international stage with regards to who builds them, who designs them, who maintains them, and that type of thing. So, the Jones Act, there's an argument that said that Congress, in its wisdom, built in, knows that it's going to cost more to build a ship in the U.S., especially a Navy ship or a Coast Guard vessel or a ship that's within the Jones Act context. And you always want, and if we don't have the Jones Act, we're going to atrophy this shipbuilding ability, and we're going to end up like the Brits, where we have no choice. We can't repair ships. We can't. We don't have a domestic shipbuilding base to repair our own, national defense ships. So that's the argument on either side of that. Now, one of the more interesting aspects, and I'll let me go back to that national security argument, because the shipping companies I represent at the American Maritime Congress, we're mostly in the international trade. A big part of what we do is carrying national cargo. So anything, the law is that any government impelled cargo, anything that goes by sea, has to be carried in some, depending on the percentage, by a U.S. flagship. Now, this isn't Jones Act ship, because most of the ships that I represent, the companies, those are foreign built ships, but they're U.S. flagged, they're U.S. owned, and they're U.S. manned. But the point is that, from a national security perspective, whether we take fuel over to the South China Sea, or whether we take food aid over to different parts, humanitarian aid to different parts of the world, or whether these U.S. ships take, war material or resupply Antarctica, or carry rocket ship parts over to, Cape Canaveral or Cape Kennedy for a launch. Do we want those? Do we want those in the control of non-U.S. mariners, non-U.S. owned companies? That's a good question. It could be debated. And from that perspective, U.S. perspective, I think one of the common arguments is comparing the Jones Act cabotage and manning requirements, bill requirements, to the airline industry. Very few people will say, well, we would like Aeroflot to fly the Cleveland to Orlando route, right, with a Russian crew, with a plane that's maintained somewhere, in Brazil, let's say, with the license and training from Russia or some other country, let's say Pakistan, for example, and owned by the Russian government, and taking that, and it's not really a foreign concept to say, no, that doesn't happen. It's going to be, United or American or Southwest. It's going to be a U.S. company. But, of course, Aeroflot can fly into JFK. And that's a little more of a kind of equivalency of why these same issues apply. Same thing with the highways. If you're driving down 95, you're going on 10 across the Panhandle, you're driving next to an intermodal truck, a 40-foot container, you're comfortable, at least to a certain extent, with that truck. But I mean, how uncomfortable, less or more comfortable would you be if that driver was, let's say, Azerbaijani, when he was licensed in Poland, and the chassis and truck were built in, Swaziland, and that truck was owned, that truck and chassis were owned by the sovereign wealth fund of Qatar, et cetera, with the insurance policy belonging to a Canadian company. It would be a little more unnerving for a lot of people. So that's one of the other arguments that folks use from a national security perspective of, for these tugs and barges or whatever have you, within the system. And when I mentioned that, I failed to mention, when I say tugs, I failed to mention that as part of the Jones Act also, they added on some other laws, which includes dredging and towing. For obvious and reasons, I think dredging is like considered a good, so to speak. Whereas, when you talk about dredge spoils, that was just deemed a material. Just because it doesn't have a value intrinsically doesn't mean it's not a good that's being carried from point to point within the U.S. So that was dredging, to clarify that aspect. And towing, I think that's a little more obvious. You want a foreign-owned ship run by a foreign crew, built outside, towing a bunch of goods and saying, hey, we're just transiting around. We just happen to have this, 600 containers on this barge behind us going from the port of, Port Everglades to Charleston. So for obvious reasons, they added towing as an actual aspect of the Jones Act. So all of those things fall under the Jones, or what we know colloquially as a Jones Act. One of the more interesting parts, and we'll get into some of this in a couple of seconds, but of the arguments from DC is what we would consider, political stage progressive folks that are talking about anti-Jones Act sentiment. And this really manifested itself in San Juan and Puerto Rico following Hurricane Maria. What that argument up here in 2017 became was these are U.S. shipping companies with that predominantly demographic that you would have for U.S. shipping companies, very wealthy, very well endowed. And Puerto Rico is suffering here, and it's because of the Jones Act. And the people that are suffering here are people of color. And that turned into something here in DC that was rallied around by the progressive base. It turned into why are folks, the people who are subject to the Jones Act, Guam, places like Alaska, Guam, Hawaii, Puerto Rico, they have one thing in common is that the goods that we get because of Jones Act are much more expensive, and the majority of people who live here are indigenous or ethnic populations or people of color. This has a disproportionate impact, negative economic impact, that's being shouldered by an indigenous or persons of color or native population. And that really had some, really started gaining traction up here in DC following Maria. And what happens, like with a lot of strange things that happen in DC, it made for interesting bedfellows. So all of a sudden you've got these conservative, pro-libertarian Rand Paul type, pro-business folks aligning with these very progressive, mostly New England, but some other parts, Democrats in the House coming together, co-sponsoring bills to kill the Jones Act. One of the most dangerous things that you see in DC is when you see this kind of like very disparate group of folks who probably don't have a lot in common politically getting together on a bill. That's a really big danger signal, right? That's a very, very, very big red flag for folks of us who happen to be pro-Jones Act. When you see that kind of army aligned against you, you need to go to the mattresses and call in all the friends that you have to try to work that down if you can, because those are the most powerful, and really. You see it all the time when you kill bills, right? You see these strange bedfellows who kill bills. It's always easy to kill bills. That's what we do in DC. We're really good at killing things. We're not so good at repealing things, because once you get that thing in law, it's real tough to repeal something. But we're really good. So you see a lot of those disparate groups come together to kill legislation, and it happens effectively. But in this case, this particular case, this group, that came together to try to defeat the Jones Act post Maria did fail, because there's a very large bipartisan group that also supports the Jones Act from all these different myriad perspectives that I had just given you. But I thought it was interesting, from a policy perspective, a legislative perspective, you see these groups come together to repeal the Jones Act. But more or less, I think I've given you somewhat of a perspective on the policy perspective. Some of the things I wanted to bring up, the Jones Act in the news or recently, that hopefully will generate some questions. One of the big thing is offshore wind, right? So offshore wind, and this harkens back when I talked about points instead of instead of ports earlier. So folks will remember, things like, for those of you who work in the offshore, Outer Continental Shelf Lands Act, right? What is a point for Jones Act for CBP to determine? So offshore drill rigs and OSV, offshore supply vessels that supply those rigs, pretty much CBP determines what is a point. And really what a point is, if it's made fast, we're talking, I'm not going to belabor the 200-mile EEZ that most of you folks know about from admiralty law classes or practicing. But if that rig out there in the Gulf of Mexico is tethered, somehow attached to the seafloor, that's going to be a point. If it's not, if it's one of what these call these like enormous MODUs or marine, I can't even remember what MODU stands for, but a drill that uses dynamic positioning to kind of keep still without being anchored or tethered to the ground, whether because it's too deep or whether it's because they don't want to mess around with the Jones Act. That is not a point. So that those vessels can be foreign flagged, foreign owned, foreign crewed, and service those MODUs at a much less expensive rate than the U.S. mariners coming out of the Gulf or coming out, west coast of Florida for that. But also, there's a wrinkle of when you're installing a rig, that Jones Act does not apply. So you can see how this can go down that rabbit hole of laws and regulations and rulemaking. What is installation? What's the definition of installing on a rig? I mean, if I'm bringing stuff out there, and I'm just altering certain things, a jack up rig, lifting platform, that kind of thing, that's, a complete different interpretation. And likewise, goods and services and people are obvious Jones Act. They go on OSVs. Things like cable laying and that type of thing is not really considered goods or service. So that's actually kind of on the installation part where Jones Act doesn't apply. So you can see some of the wrinkles in that. The reason I bring up OSVs is this offshore wind is getting very big right now, right? And the administration is really hitting the gas on getting this wind farms installed, whether it be off of New England or Virginia. But really, the U.S. doesn't have the domestic ability right now to build, install, service those rigs. Europeans and Northern Europeans specifically kind of own that space technological wise. So I don't know if many of you were at the Workboat Conference down in New Orleans a couple weeks ago, but when I was down there, it was really an interesting dynamic between these European companies who were trying to find U.S. partners because they knew they were going to run up against a regulatory brick wall when it comes to Jones Act issues. And it was just one of those things where you could see this. Nobody knew how it was going to develop, but they knew that the Jones Act was going to, be effectively something that they had to contend with in the next couple of years as they work towards offshore wind farms. Something else that's just recent aspects is the waiver process, right? So the waiver process, whether that be the government under national security can give a waiver to the Jones Act. The last time this was done was the Colonial Pipeline. So remember that back in ancient history, but the Colonial Pipeline stopped up, gas shot up to X amount a gallon, and there was an outcry. So what they did was they said the Jones Act is lifted. Now some petroleum tankers could go from the Gulf or back and forth to U.S. ports up in New Jersey for refinery purposes to ease the gas crunch. It was also granted during Hurricane Maria because Puerto Rico was saying that they could not get the goods that they needed. And there's also a waiver that was granted very recently to the PVSA, which is the vessel, Passenger Vessel Services Act, which is basically, like I said, part of the Jones Act, talking about cruise ships. With COVID, what the cruise ships were doing was they were going from the West Coast, Seattle, always stopping in Vancouver, and then going on to Alaska for the Alaskan cruises. COVID, Canada shut down that border with COVID, and they were forcing folks to there were not Jones Act vessels. There's only one Jones Act vessel that is in the cruising business, and it's out in Hawaii. And frankly, it's only there because you're not going to be able to make a foreign port out there. So and then that took a special exemption because that vessel is not a U.S. built vessel. It's just U.S. owned and U.S. crewed. So that's the NCL America. I think it was part of the Americas that is actually out there servicing the Hawaiian Islands. But these Alaskan cruises, they're all non-Jones Act vessels, but they normally stop in Canada. So they worked around that. There's still a law to try to, to permanentize that waiver. Senator Murkowski, from Alaska is working on that in order to, because, cruise ships in Alaska is a big part of the economy there. And I think that, they're working through that in Congress right now. We don't think it's going to be permanentized, but that was another reason that there was a waiver that was granted recently. So I've gone through a whole laundry list of things. I didn't really, it's hard for me to get a sense of the audience is interested in, or if they're interested at all, to be honest with you, because I can't read your faces or see you. So I'd like to open it up to any questions or comments, anything from a DC perspective. Specifically, I'm not going to be too great on any type of legislative, legal aspects of the Jones Act. There's plenty of it out there. There's plenty of law review articles and plenty of commentary on that. But from a kind of a DC person's perspective, who's more or less been in this business for about 8-9 years now in DC, I wanted to open up the floor for anybody who had any comments or questions.
All right, you guys can either send the questions through the chat or the Q&A. It works either way. Well, fair. I actually have a question. Is there any pending kind of bills that are going to impact any of those issues that you mentioned, and kind of what's the status of those? I know there was a large infrastructure bill. Was there any Jones Act related issues in the infrastructure bill that just passed?
No, there wasn't. So Senator Lee did put, this last version of NDA, he did put an amendment to repeal the Jones Act. That was beaten back. The Murkowski bill, I think that's still floating around there. That would permanentize the waiver to allow cruise ships, non-Jones Act cruise ships, to continue to ply waters between usually Seattle, SeaTac, to Alaska for tourist purposes, without having to stop in Vancouver, British Columbia. And that is, I think that's, doesn't look that good to pass, because, most of the counter argument is just, let's just have a waiver that, if we have anything that accommodates those cruise ship passengers, let's have it tied to the Canadian government. So if Canada does close Vancouver again, then let's have it so we don't have to have this waiver process, this cumbersome waiver process to work through. Let's just have that in law. And really, from a legislative perspective, if we know we're on the losing side of a policy argument, we'd much rather have them put a law and put a law that's helpful to us that we lose than to just completely kill it. And that sounds kind of counterintuitive, but it's kind of one of those things where you keep your friends closer, enemies closer. If we can statutize that law that barely hurts us, but we've got it there, we can always refer back to that as a compromise that we've worked out before, as opposed to fighting this battle every year and worrying about maybe the committees change, maybe the majority changes, maybe we lose some of our champions in Congress. That's one of the big things right now is there's a lot of moderates leaving Congress, and most folks who, I don't want to categorize too much, most folks who support the Jones Act are more moderate than their peers who don't. I'll put it that way. So that's one of the truisms that we have with the Jones Act. And if nothing else, from an economic perspective, we're talking about jobs, hard numbered jobs, and U.S. business owners and U.S. citizens at stake here. So really nothing on the pipe with the Jones Act. I will say this, our traditional battle lines are the U.S. the shipping company themselves and U.S. unions pro Jones Act. The shipbuilders are not as, different parts of the Jones Act. So when I say different parts of the Jones Act, let me talk about some waivers There's statute, so like I mentioned, Northern Marianas, Samoa, U.S. Virgin Islands are completely exempt from the Jones Act. Guam has 2 of the 3. Doesn't have to be a U.S. built ship to service Guam. Puerto Rico, you can have cruise ships that are non-Jones Act going to Puerto Rico from the mainland U.S. Those are exemptions that are out there. And if you look at that, folks like the Heritage Foundation and Cato Institute, those are the think tanks out there that are very anti-Jones Act. Their philosophy is not all the Jones Act is bad. If we could just tinker with it, different perspectives. Let's just, and really the strongest one is the U.S. mariner's perspective. There aren't too many folks that say, yeah, we want foreign labor to be on these ships. So that part of it is the U.S. ownership part is also, fairly inoculated from a lot of argument. The biggest part of the Jones Act is the U.S. build requirement. That is probably that is where that is where the overruns and cost estimates come from Cato and Heritage and folks from, I'd say it's just too expensive. That is where if folks would be like, you know what, if we could just carve out the U.S. build, let's make everything like Guam. We're great with 2 of the 3. You take that U.S. build requirement away, the shipyards can't, the whole purpose of the shipyard, the Jones Act was to sustain this U.S. shipbuilding capacity. And yet your shipyards have, dwindled. So it's not doing its job. So that's one of the arguments. And the counter argument would be, well, if we did have a Jones Act, these shipyards would be completely eliminated. So let's protect what we have. But that's probably one of the weaker, the Achilles heels of the Jones Act. If the hard left progressives from a progressive standpoint on a cost basis could garner their allies across the aisle on the libertarian pro-business side, low taxes side, low cost side, and could start working on carving out, minimizing that build requirement of shipyards and repair facilities and that type of thing, they'd have a much more powerful argument. But, the Jones Act folks are kind of like united. Those 3 legs of the stool are very, very much intertwined. So I don't foresee that happening soon. But that's the next kind of, legislative step that we see folks trying to take is let's not take out let's not just repeal the Jones Act. Let's take it out a little bit at a time. And once that Pandora's box is open, maybe there's a little more traction with being able to repeal larger parts of it. Brian, you're muted. Brian, you're muted.
Sorry, question from Stephen Moon. How could we help educate our representatives that the Jones Act is important to national security? So I guess, my follow-on question to that is kind of, how does the average citizen kind of impact on these large issues in DC? And your insight as a lobbyist would be, I think is important. So.
Yeah, grassroots lobbying is very important. And nobody is more important to a member of Congress than their boss. When I say their boss, I mean the people who put them in there, hired them and fired them. Their constituents are the most important voice. If you are a constituent of a member of Congress, they will always pick up the call. They'll always respond to any correspondence you have. They'll always see you on a face-to-face visit if you ever come to DC. But as far as a proponent of Jones Act, I mean, how does it impact you? I mean, is it your job that we're talking about? Is it the company that you work for? Is it, and to answer your question, Stephen, from a national security perspective, what's the alternative? Do we want to subjugate our entire, who do you want pushing the barge? What kind of ownership and licensing regime do you want pushing a barge of LNG up the Mississippi, into the port of Tampa? Do you want to have control and dominion as a country over who's plying those waters? You have it in the air, you have it on the highways. Why wouldn't you have it in some of the most vulnerable infrastructure that you have from a national security perspective? This isn't like, atomic bomb scenario, mutually assured destruction. When we talk about national security, we're talking about low intensity infrastructure attacks, right? From a foreign power. How would you effect something like that? Well, you would do it on a smaller scale, via the waterways. right? I mean, that makes the most sense. That's the most accessible. That's the most kind of under the radar, in terms of just, trying to remain, to having a large impact, a disproportionate negative impact based on their resources. So I think from that perspective, I mean, do you care about who plies your waterways, and where that ownership? Again, back to that highway regime. I looked up, and I wasn't just throwing when I said Azerbaijani Poland. I literally looked up highest accident rate, car manufacturer, highest liability rates for drivers. I literally looked up, in some database, the worst of everything in terms of driving and liability and construction of the vehicle, and put those together for that example. I wasn't trying to single out any other country necessarily, but those countries, I mean, that's what you're talking about. Everybody would be fine with, everybody's fine with the fact that, these trucks are licensed. I mean, there's a big issue whether truckers, commercial truckers can be 18 or 21. Right now, you can't be an 18-year-old and drive a commercial truck. There's a big outcry over that for safety. Can you imagine if the issue was not just the age of that person, but whether he was, licensed in the U.S. or whether the truck he was driving was made, was inspected under the safety regimes of the U.S. or his tires were inflated the proper capacity under, et cetera, et cetera. So that same argument applies from a national security perspective, but it also applies from a warship perspective. Do you want to subjugate the design and build and maintenance of your U.S. vessels to a foreign nation because it's the least expensive option? And I will say, one of the arguments, and again, most of my ships aren't technically all Jones Act, because a lot of them are built foreign in foreign places because we're in the international trade and it doesn't apply. But two of the three prongs of the Jones Act, U.S. mariners and U.S. owned and U.S. flags, we do a lot of food aid, and there's an argument, well, food aid should benefit the most people at the least amount of cost elsewhere. And I understand that argument. I understand that it's a very powerful argument. If you could just transfer this food, through a teleporter machine, or have them be able to buy their own food somehow in a safe manner that wasn't subject to the corruption of transferring funds to an individual, of course, that's the greatest and the most deliberate means of helping out on a humanitarian. But the U.S. aid bag, for those who are familiar with it, it says from the U.S. people on the side of it, and it's grain from Arkansas, or, rice from Arkansas or Mississippi, and grain from the upper Midwest or Nebraska, and corn from the States, things like that, or cooking oil. Those go across to other countries, and really, I mean, did you want them? And there's a public policy and a national soft power, national security perspective of aiding these people in these different countries on a food aid basis. What's the difference if that bag of, if that bag of rice comes off, and it's from the American people, but it's not by the American people, right? If it comes off and the flag is not a U.S. flag, it's, the cheapest cost, whatever, Marshall Islands, Panama, China, whomever. I mean, does that make a difference? I think it does. I think there's a fair argument that it does make a difference. And it, a lot of us are very accustomed to paying a little bit more because we're talking about fair source trade, right? You worry about the collective in Kenya that is paying the women, a certain amount of living wage, or in Colombia or wherever, and it's those beans that you're getting are fair trade. So I'm going to pay a little more. I'm going to pay $4.50 for that cup of coffee because I have this social conscience that keeps me, thinking about how those beans were sourced. But nobody talks about the transportation, right? So those beans, sure, they're sourced there, but how do they get over it? Most likely they went on a foreign flag ship, because 98% of the goods that are imported in this country go on foreign flag, foreign owned, foreign crewed ships. With, for those who have worked, on a Coast Guard legal perspective, some of these ships are just, they're terribly run, they're terribly maintained, and they're terribly, they're owned by terrible people, frankly. Having work security agreements where they'll abandon the ship, for abandon the seamen themselves in port if, if there's an oily water separator case or a documentation case. And I'm getting kind of off the scope of the Jones Act, but I'm still talking about U.S. mariners, U.S. ships, U.S. shipping, which is all part of the argument here from a policy perspective. But, shipping and admiralty is invisible, right, to everybody except us that are in the business. It's invisible. When we drive on the highway, we see the trucks next to us. When we go on the railroads, we see the trains, or even in your cars, we all fly in air. Shipping, as we know, is invisible. So that's why part of it, back to Stephen's excellent question, as a grassroots movement, that's why you have to make sure that your representatives and folks, even your mom and the mom and pop people in your everyday to-day life type of thing, kitchen table type stuff, know about it, because this is an invisible industry in a lot of things, in a lot of ways, and we all pay a cost for that,
Fair.
iPhone cover, but it's just that much less expensive. Go ahead, Ryan.
Fair. Have another question kind of along those lines. It's from John Thomas. He says, do you have any thoughts about U.S. manning requirements for autonomous vessels where the control is from shoreside?
Ooh. Yeah, I mean, I represent, so I don't know enough about that. I do know that's a contentious issue, right? So autonomous is a bad word to folks in organized labor, right? Because you're just like, you're a robot, you're gonna take my job. It's not that simplified, but that's the gist, right? The more autonomous something becomes, the less human interaction there is, the more chance there is for something to go awry. I'm not saying it's gonna be like, I don't know, what is that? Like, I can't remember the Terminator, like, overarching architecture, system net or something like that. It's not like that, that extreme, but there are examples of autonomy, autonomousness that, for the sake of cutting costs, you do cut out, a lot of that human interaction and intervention, right? So same thing goes with AI. I think that's a very big concern. I think the closest equivalent when we talk about autonomous vessels, drones, right? Now, there's a little there's an argument out there that says, like, when a drone loses control or its operator, it drops out, it could kill people, hurt people because of gravity. Those that say, well, there's tons of shipping containers that float around in debris, flotsam, jetsam all over the world. Yeah, it's a risk worth taking if you lose, control of the vessel autonomously. I think there's a lot of good things happening with that. From labor unions' perspective, I think there's concerns about retraining into that. Another maritime aspect of autonomy you'll see a lot is ports, right? A lot of the ports have these cranes that are super autonomous. They're putting these AI things to take these, thousands of shipping containers, boxes off of ships more, quickly. I wouldn't say more efficiently, but more quickly at times. And there's a big fear. One of the fears is that stuff is software based. The other big fear is, like, the #1 crane builder for ports is Chinese, owned by the Chinese government. It has a software, Internet of Things, that talks back and gets software updates from China. So there's a national security concern with that also. But as far as your question is autonomous, I don't know. It's just a strange thing to me. I think of autonomous vessel and I think of a model boat and kind of lack of control I used to have, like working a model ship with engines. As a mariner, as a former mariner, it gives me a little bit of pause. I think that's the way we're headed. But I think it's still probably too nascent of a technology to really speak confidently on.
We have another question. It's from Todd Studley. He asks, does the Jones Act impose any environmental regulations on the ships? Is there an environmental component to the Jones Act?
Not inherently. There's nothing in the Merchant Marine Act that says anything. But for those of you in the industry, you'll know if you're U.S. flagged, U.S. owned, U.S. built, you're going to have a lot of environmental stuff built in, right? Because of port state control of the Coast Guard. So you are going to have elements that now, everybody talks about IMO versus the U.S., but clearly the U.S. regime is one of the strong in the world when it comes to that. The answer to your question is no, but you can see that, if you build a ship in the U.S. shipyard, you're going to have to follow U.S. environmental laws. The same thing if you break a ship, right? So, Jones Act doesn't apply to breaking a ship, but shipbreaking, look at where shipbreaking happens. What parts of the world and the types of environmental impacts of shipbreaking. So reverse that context, and you're going to see, just because of the fact that it's built in the U.S., You're going to have to comply with a much stricter environmental regime because of those are U.S. mariners with U.S. licensing, and because of the port state control of the Coast Guard. Inherently, you're going to have a layer of environmental protection that is not going to be realized with non-Jones Act vessel. That's a really good question. I wonder if there's a way to quantify that or metricize that. I'm sure people have looked at it, but no, the law itself does not impose that.
Fair.
Let me qualify that very quickly. So something in the PID, the Port Infrastructure Development Grants and the META grants, these are U.S. Maritime Administration grants funded by the BIF. So tens of millions of dollars, hundreds of millions of dollars coming down the pipe. Those grants do have a lot of environmental things built into them. And those, when they disseminate those to places like shipyards and to buy Jones Act barges and to do things for short rail shipping, those do have that discretionary ability for the administration to impose those climate and as well as equity restrictions and labor restrictions on how that grant money is spent. So that's probably more of a practical impact of what you're referring to. Go ahead, Ryan.
Yeah, fair. We got a new question from Mr. John Thomas. He asks, I wonder how the calculation would be done for U.S. origin for ships operating software. Is software a part of the calculation as it relates to U.S. origin for these new high-tech ships?
Yeah, that's a great question. I didn't get into the build requirement, right? Because basically, what's the definition of build? The Coast Guard determines build with what they call these letters, right? They write these letters, and if anybody looks up America's Finest from Dakota Creek Industries Shipyard, they'll see this huge saga of what constitutes build. So in general, if it's fabricated, if it's the envelope of the ship itself, it's build. Those are obvious, that is build. With a certain exception, like 1.5% of weight by, steel weight by weight can be foreign. So usually that's rudders, propellers, other implements can be foreign as long as they don't go over that 1.5. Appurtenances and superstructures and weird things, there's all kinds of letters out there of what constitutes a build. But in general, like the inner guts and wiring and that type of thing can be foreign made, foreign procured. But just so the general perspective of the build, but it can get very complicated very quickly, especially when you talk about repairs and shipyards, right? There's instances where they come in, they'll go to Singapore and have a section of the ship put in there, and it won't qualify for the build because a section of the ship was with steel that was U.S., but the rest of the ship, they'll elongate the ship with it, some of the other components, it won't constitute a Jones Act infraction. There's other cases where they took some steel, they bent it, and they manipulated it some way. And anytime you do that, now you're talking about that has to be 100% or 98.5% U.S. and shipyards have gotten in trouble with that. To your point, though, that's a great question because there is going to be an aspect of that, right? Because you can't say that software is not going to have an increasing footprint economically, but also structurally. You can start making the argument. This is a software that determines the integrity of the hull, so it's more of a build issue. I could see those arguments playing out, but that's a great question, and maybe looks like an opportunity for some folks.
Yeah. Hey, Fair. We're running out of time here, okay. And we got one last kind of good question here from Christopher Keeler. Says, who is the greatest threat to the Jones Act? Besides people like Mike Lee and the Cato Institute. So what is the greatest threat to the Jones Act that you see?
Oh gosh, I think I'd reiterate, Chris, what I said before. If people start really hitting, if they break down what the costs are of the Jones Act, they'll see most of it comes from the build part. And if you start messing around with some laws that talk about build and maybe why can you have a propeller and an engine that's made in in a foreign country and not, you're talking the skin of the ship? Something's wrong with that, right? So something's bizarre about that. Because the Jones Act, remember, this came from the days when the U.S. was very held. Ships were made of wood and we had a lot of timber. So now that the steel is in there, I think that's probably the greatest set. Is if those people put together, and this is probably a playbook from Cato, if you guys are big fans of theirs, if they put a playbook that attacked the actual highest percentages of the higher costs are going to be from the shipyard part, and take those, peel off the build part, and you're gonna be like, well, U.S. foreign ships like Fair's, company represents ships that aren't built in the U.S. They're doing just fine. If you could find that argument, it'd be a very powerful wedge issue, breaking our Jones Act coalition that we have. It's a great question. I appreciate it.
Well, hey, I just want to I want to say thank you, Fair, for taking the time out of your day. I know you're busy up there in DC, and appreciate it. And it was you can look at the chat and see the feedback that you got. So take a moment and just so everyone knows, Stephanie did post the CLE credit number, and I'll send out the actually I think Stephanie's going to post the actual course in the chat room. So, all right. Well, thanks a lot, Fair.
Everyone, thank you. Happy holidays.
Thank you, Fair.
All right, thank you all. I'm going to go ahead and close down the recording now as well.